or owners to have the benefits from their work when these are exploited commercially. These rights are statutory rights ground in accordance with the provisions of corresponding intellectual property legislations. In totality, intellectual property rights reward creativity and human endeavour which fuel the progress of humankind. A trademark law, also popularly known as a brand name, is a visual symbol which may be a word, signature, name, device, label, numerals, or combination of colors used by one undertaking on goods or services or other articles of commerce to distinguish it from other similar goods or services originating from a different undertaking. Trademark law governs trademark and other aspects relating to it. It is the pleasure of our institution to host a webinar series on intellectual property law. Yesterday, we had the first session on patent law titled Understanding the Relevance of Patent Law in the Technology Driven World. And today, we have the second session on trademark law titled A Primer to Trademark Law and World Intellectual Property Organization. To educate us on this topic, we have Assistant Professor Pusrala Bayola Kiran, esteemed faculty member of Damodaram Sanjeevaya National Law University, DNSLIU, Andhra Pradesh. It is my pleasure to welcome the learned speaker, faculty members, and participants. Before we start the session, I feel happy to present a brief profile of the resource person. Pusrala Bayola Kiran has completed his BA LLB honors, securing 7 gold medals at Damodaram Sanjeevaya National Law University. He obtained LLM in Business Law from Dr. B.R. Ambedkar College of Law, Andhra University, and holds a postgraduate diploma in Social Exclusion and Inclusive Policy, and also published various research articles and papers in reputed journals. He is currently serving as Assistant Professor in Law at Damodaram Sanjeevaya National Law University, DNLIU, and pursuing his PhD at Dr. B.R. Ambedkar College of Law, Andhra Pradesh University. With this brief profile of today's resource person, I extend a warm welcome to one and all here. Over to you, Professor.
So you're not audible, sir?
Am I audible now, ma'am?
Yes, sir. Yes, sir.
Yeah. So what I'm saying is we'll start with a very small task. All of you have your devices. So just download the Trademark Act and keep it ready, because we are not going to have any PowerPoint here. I want students to fall back on the Bear Act, refer to the sections like in the traditional method. So we'll use the advantage of online for easy access, but we'll try to have it in the typical offline sense where you will still feel the book. Thank you so much. With that small request, let's proceed. Now, when I got a request, or let's say maybe I would even call it as an offer to deliver a few ideas on what is trademark, how it is to be registered, and it went on. We're talking about assignment, WIPO. I was initially perplexed as to how do we cover all these ideas in 90 minutes. But I confess I try to be as simple as possible. I'll touch upon the peripheries. Maybe wherever possible, I'll just give the names of the cases where I feel that it is relevant. I won't trouble people with the citations. I'll only try to give the ideas. So in that context, this will be a primer for you. Use your Bear Act, then fall back on a textbook, then consult the respected teacher for knowing better, right? Now, all of us are using the device as of now. Now, if you are using Google Meet like we have, does Google Meet symbol is distinct from Gmail symbol? Gmail is Google's email. So you got Google Meet, which is Google-based online meeting system like maybe Zoom or Cisco WebEx. Now, why are they having two different, let's say, should we call them logos or images? So what is that is coming? Why can't they just have G for everything? Or if you remember, maybe 4 years ago, Google had, um, in a sense, resigged all the symbols. You have an M appearing on the letterbox, that is the envelope cover that is there as a Gmail logo. So basically, we see an M, but with the Google colors. Wherever it loads, we would see red, green, yellow, blue coming in for sure. So that is there. That is predominantly there. Or if you just minimize your screen, look at the Gmail symbol, calendar symbol, or Google Meet symbol, you have the dominant colors flowing there. But we are very clear that all this belong to Google, not just because it is written as Google. We have something called as Pixar at some point of time. Now that was taken over by Google, and now it is one part of Google Photos. Now you got OneNote or various other options. So the consolidation of technological companies, wherein the bigger fish is swallowing the younger and a bright fish which got potential, you got the conglomerate turning out to be something which is very big. But over a period of time, for example, every time when we try to look at, maybe if you are opening the Google Meet in your desktop or laptop, you find that 9 dots. If you click on the 9 dots, you get to see all Google products, and you scroll down, it say, what are the other ones. So you got Google Scholar, or for that matter, Google Sheets, Google Forms, Google Docs. So we are, in a sense, trying to understand that this has some relation with the Google, maybe the services that we are using. Now, is Android with Google or Google with Android? Any ideas on that? Android owns Google or Google owns Android?
Google owns Android, sir.
Sure. Now, who owns Google?
Alphabet.
Alphabet, sir.
So that is another reconsultation that had happened, let's say, in the past 5 years. Now you got Google being subsidiary of a bigger technological company. But if it is Alphabet, and there are various other products that are being taken over by Google, why are we still using Google for it, and why are we not calling Alphabet? So that's when the whole idea starts as to what is this trademark, and why are people are asking about various notions. Maybe to start with, what does the trademark do? Once we understand what does the trademark do in the colloquial sense, then we go back and try to refer the historical notions. People say that a trademark identifies the traders or distinguishes one set of goods or services from others. So we know, yes, this is Google Mail if it is Gmail, looking at the logo, or it can be something like a Yahoo Mail or a Rediff Mail. So that small maybe logo, or maybe a device. We talk about all these terms with reference to the definitions wherever possible. But the idea is, when we see, we know, yes, this is so. Or when we try to go to something like MG Road, Brigade Road, we get to see all possible shopping places. We distinguish things, we call it brand, right? Maybe there's a difference between, let's say, Imperio, Gregorio Armani, or Levi's. We are talking about different notions that created in us by looking at, or by feeling that trademark, whatever the description that we give it. So it is used to identify the goods or services of traders and distinguish them from that of others. Are we okay? Are we okay? Any questions? People say this is the first dominant function of the trademark. It helps us in identifying whether these goods belong to one set or another. Now then comes a serious question. So if that is so, is it something like a property mark? Because under criminal law, you would have studied property mark for sure, right? Any idea as to what is a property mark? So section 479 of IPC defines a property mark. It is generally affixed on mobile property. and it is personal in sense. So, for example, let's say, just give me a second. So I may have some kind of a name printed on my book, or something that can be stamped on a book. So what I do is I say that I got a stamp made which says this property belongs to Viola. Maybe if I can find it, I'll show you. So this is personal instance. This we are saying maybe it's more like an indication of my property. But when we talk about trademark, we are not talking about movable or removable. We are talking about goods and services, right? It is used in trade. When we find a Levi's mark on a jeans pant, it is not indicating that it is owned by Levi's. It is made by Levi's. It is ready to be sold, and we can buy it, right? So that's the serious distinction that we have to be kept in mind. So property marks of personal, trademarks are used in trade. Maybe the literal translation: marks used in trade are trademarks, right? Now, it can cause a little bit of confusion when we say that property marks are used for identification. Yes, maybe there'll be things like few engravings that are happening on silver plates, gold plates, which indicate that this belongs to somebody. But when we talk about trademark, in trade sense it identifies, but what it actually does is it marks the origin, right? This pant is coming from, this jeans is coming from Levi's, right? So when we talk about that, the notion that I was referring to earlier, it takes us to the idea that yes, if Levi's had made it, it had got some quality, because over a period of time it is established. So when you get to see a Levi's mark on, let's say, on a shoe, we are very clear that we may find Levi's jeans, but a shoe, or when we find a Levi's pen, right? So these marks associate in trade with the soles. Now, just because it is made by Levi's, will it be of the same quality? Or they always say, Tata means trust. So anything that is made by Tata, should we consider it just like that? So we're talking about origin. Are we okay? So the second one, in the sense, is it identifies the source of goods originating from a single source for all products, like the Google idea that we have. Everything, Google Docs, Google Forms, Google Mail, everything is originating from a single source. Then you have something like maybe a typical beverage. We talk about some of the beverages, alcoholic beverages, non-alcoholic beverages. These stand up for certain ideas that are to be crystallized over a period of time. So we talk about quantity. If it is this beverage, this comes only in these quantities, nothing more, nothing less. So if it is trademarked in that company, or it is coming from that producer, it can only come in that quantity. So it signifies that it is of equal quantity. That is another use that they talk about. And leaving all this, we talk about all the campaigns that are happening. Maybe all the advertisements that we see in YouTube, the skippable ads, unskippable ads, or the ads that we have on the OTT platforms, or maybe the cricket matches that we get to see. We get to see a lot of ads. In all these ads, they use the trademarks, right? For example, what is the trademark of MRF tiles? Any idea? What do we see whenever we think of MRF? What are we seeing apart from MRF? Do we see something else?
A man carrying the tire, sir?
Tire pattern.
Tire and anything else?
Pattern.
I think we find a man up to his torso with two hands on the tire, right?
Yes, sir. Yes, sir.
So we are talking about different kinds of things that can be called as a trademark that can be used to indicate, you can have a tire, or you can have, maybe I'm please don't accuse me of being gender specific, but the notion is we're talking about a strong man, so the tires all strong. So we're talking about all those ideas that flow from it. So they indicate that yes, this is of something. Now, do we have things of this sort anywhere else in the history beyond the modern industrialization happening? People say that when we dig deeper, I think there's this wonderful source called as Dr. Sharon Oho, a history of Japanese trade, trace what are the various things that can be seen. So they are talking about pottery marks on, let's say, in Greek and Roman markets, right? A potter trying to make. We talk about the Japanese tea kettles, or maybe the black clay ware that we get it from the Eastern Asia, or we talk about porcelain that gets its origin in the Central Asia or in the Arab countries. We are talking about things which are there pre-industrialization. So there they wanted to have an indication of where is this coming from. So they were Potter marks. So if it is coming from Mr. Potter X, right, that Potter is somebody who stands for that quality. So way back, maybe 5000 BC, 3000 BC, they were seen some kind of marks, right? Not exactly like the trademarks that we have, but it had generated way back then, and it was ownership mark or property mark, or if we are talking about seals which indicate the quality or the quantity. We are not talking about measuring. Now the biggest concern that we have to keep in mind here is there was no universal language. I'm not saying that we have one universal language as of now, but the mode of communication, in a sense, was dependent on somebody who knows both the languages. So even without depending on somebody, can somebody indicate quantity, somebody indicate quality? So all that had come into picture. So the black pottery, maybe the roof tiles of the first dynasty of Egypt, or had some ownership mark printed, or prior to that, the Greek pottery got its own idea, or then maybe typically speaking, the mercantile idea had walked in 12th century. Well, they formed trade guilds, the groups of people, right? Something like today we talk about the rampant infringement that happens, especially in relation to alcoholic beverages. So we talk about scotch, single malt, double malt, scotch, whiskey. Now, Scotch is per se an identification. We're not talking about trademark, we're talking about identification of a source. So we're talking about who can use it. Can somebody who's not from Scotland or in the area, can they manufacture Scotch? So you got all those cases that are there. So the notion is this trade guilds, people who make that. Maybe somebody like the initial printers after Gutenberg, who had got control of it, they would say that nobody would make books without having certain pattern to be followed, right? It can only be sold once we get it recorded. So they say that yes, these are the limited number of copies that are made. So you would cut down certain kinds of infringement. So we are talking about both copyright law and trademark law. The notion is the traders guilds had tried to come up, an identification factor, or a quantity factor, or even a quality factor. Now that went on, and other professions took it. Maybe in the 13th century, they got something called as the bell marks. The makers of the bell tried to have bell marks. Then you got paper marks, which had appeared in Italy for the first time. Then baking had a lot to do with it. So the trademark law, or the marks for that matter, we have certification marks. And for example, simplest one is when we try to buy gold, we try to look for something called as hallmark, or we talk about agricultural products with agmark, 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 or silk mark, wool mark. So we are talking about certification, right? So marks had been part of commerce over the period of time, but what happened with the trademarks is the association of one product or one service in the today's context with one company has a lot to do with the interest it generates, the trust it generates, the profit that can be built upon, right? So we also talk about what is called as goodwill. So we'll see at some point of time if time permits. So with that notion, laws have developed over a period of time in different countries. Maybe in the Indian context, you can talk about the first law on trademark can be Indian merchandise marks of 18. Let me check. 1889. Then you got a Trademarks Act of 1940. Then it was both of them were replaced by Trade and Merchandise Mark Act of 1958. Now this is all going good. But remember, the world had turned out to be global world, a small world, and we had opened up our markets for everybody. So we got liberalization, privatization, globalization happening. So in with that notion, you would have understood that there is something called as WTO and TRIPS, right? So because of TRIPS, you had to alter some of the aspects of your trademark law. To be very specific, when we talk about TRIPS in relation to trademark, articles 15 to 21 of the TRIPS agreement. Article 15 talking about protectable subject matter. Article 17, what are the rights that are conferred, if a trademark is given. And Article 17 is what are the exceptions that are to be considered in relation to members, and how they have to do it. Now, the simplest notion is what kind of trademark cannot be permitted. We talk about descriptive ideas and all that. Now, what cannot be registered? And these are based on the exceptions that are envisaged under Article 17. Let me read the proper content of Article 17 of TRIPS. Members may provide limited exceptions to rights conferred by a trademark, such as fair use of descriptive terms, provided that such exceptions take account of legitimate interests of the owners of the trademark and third parties. So what can be done? Can a description be made? For example, can somebody say that I want to, market my shirt as the best shirt, so I would trademark it as best? So we're talking about description of the quality. So if I trademark it as best shirt, can any other seller, any other manufacturer of shirts or textiles have the term best used in their production campaign? So we are talking about description coming into picture, right? So descriptive trademarks are generally not considered, but in certain jurisdictions, some are considered. That's why we get these exceptions coming in. But you have to refer in the Indian context, Section 9 of the Trademark Act, which talks about absolute grounds for refusal of registration, right? What sort of a trademark can be refused just like that, right? There they talk about something like devoid of a distinctive character, or which may serve in trade to designate the kind, quality, quantity, intended purpose, values, geographical origin, or time of production of goods or rendering of service. These are things that are rejected, just like that. If you are saying that this is the best shirt, or this is the best aerated beverage, or this tastes something, or this is a liquid. So any description of that sort through your trademark can be refused at the application stage. Now there can be a question for sure, can there be an unregistered trademark? We'll go there, right? But before that, we are talking about the general law that is applicable. So we were talking about the 1958 Act, which was to be altered by virtue of liberalization, globalization, India becoming part of the WTO, TRIPS agreement coming into picture. So we got the Trademarks Act 1999, which is the governing law for us for the time being. Are we okay so far? So let's have a very small quiz. Which is the first legislation on marks in India? You can use the chat box. Which is the first legislation on marks? You can unmute or you can use the chat box. 1940. That's trademarks, the Trademarks Act 1940. But before that, we spoke of Merchandise Marks Act 1889. Are we okay? So you got the 1889 Merchandise Marks Act, you got the Trademarks Act of 1940. Both were repealed and replaced by Trademarks and Trade and Merchandise Marks Act of 1958, which is modeled on the UK law, of Trademarks Act 1938. Somebody raised their hand. Yes, please. You got a question? I can't find it. Okay. Now, from there, we moved on to the idea that we have the law which is on par with the standards that are envisaged under TRIPS. So basing on that, we got the trademark rules 2002. So whenever we talk about registration or maybe examination of a trademark, we can't just base upon the BEREC that I've been asking you to refer. You should also look at the rules in question, the trademark rules 2002. So the governing law of trademarks in India is the Trademark Act 1999 and the trademark rules 2002. So far we try to understand what are the functions of the trademark, what is the law that is there. Now moving on, when we say that there are various things that can be used as trademarks, maybe let's talk about something like, right now I'm referring V.K. Ahuja's intellectual property rights. Now what I want you to see is what is given here. Can somebody read what is given here or describe what you can see?
So it's not so clear, sir.
LexisNexis.
Thank you. And can you see something here?
Yes.
That's
the
the
mark.
That's
Yes,
a
logo.
some circular object,
Yes.
right? Now let's take one more idea. Yeah, maybe just a second. I should have got things ready, but still. So I got a watch here. So you'd find something right below the 12-hour mark, right? I'm not asking you to zoom in and strain your eyes, but we have various kinds. For example, if you have a watch right now, check is the name of the watch company written or given in text, or do they give you some kind of a symbol, right? So trademark, yes, please.
some kind of symbol, sir.
Ms. Devi, yeah, okay, thank you.
Yeah, it's some kind of symbol.
So when we have a Titan, we have a different logo. Fast Track or Sonata or Police. So we have different things that are coming up. Things that are written in their total spellings, or maybe a single alphabet, or something which has nothing to do with it. For example, we see cars today. Bangalore is known for its vehicular traffic. So do all car companies give out the names of their companies on the car, or do they use something else? No.
They use the logos of
Logos.
the companies.
So how does the Kia logo look? It looks with KIA, right? Kia. Or the Volkswagen. So we're talking about all possible, business considerations that they have. Kia is only 3 words, so they can, have a logo with the name in it. Now, Volkswagen, can we have Volkswagen written, or the Volkswagen to be very specific, the Volkswagen, right? Can it be written like Kia on every car that they have, or everywhere that they want to use it?
No.
So they try to have, like we said, we are talking about the origin or identification. So they find something. Or okay, at least Volkswagen got a V and a W, right? Now what happens to Mercedes-Benz? Do we have an M and B, or B only?
No, they have their separate logo.
right? So we are talking about different things that can be used, or different kinds of marks. So you have, what is a device mark? Maybe a pictorial representation of things. For example, yes, Chetan, you're trying to say something? Okay. So when we're talking about a device mark, how many of you remember Fevicol's logo? Fevicol, any idea? So you have, two elephants trying to pull something, or you have the Levi's logo, two horses trying to pull apart a jeans pant, right? So we are talking about a pictorial representation. So you got a device. Are we okay?
Yes, sir.
So also you got something like a brand, maybe like some kind of symbols that are used, maybe, or it can be words or figures. So you have maybe the buttons on the jeans, or maybe some kind of, maybe the MRF idea, wherein we just spoke of torso of a man trying to lift the tire. Or you may have a heading also, something like an inscription, right? Maybe the earlier versions you can see on we'll just stick on to jean pant for this idea. So when you have that leather patch on the right side of the belt, you find the logo, along with it some description that is being given, something that in words, Levi Strauss and Company, Pepe Jeans and Company, right? So you got some kind of an inscription coming into picture. Or you can have a label. It is, label is a composite idea. It can be a device, or it can be device, words, or it can be heading, all of them put together, you got a label. So the idea that we just spoke of, the rectangular patch that you find on jeans pant, can be the label. So we call it colloquially as the label also, and technically it is the label. It contains the device or the device mark, and it may have some heading with the words inscribed in it. Are we okay so far?
Yes, sir.
Are we okay?
Yes, sir.
So
Yes, sir.
what are the different kinds that we've seen, so that we tried to look into so far? Different kinds of marks.
It's like a symbol,
Symbol,
any alphabets.
device, brand, heading, and label. Right? We are not looking at sections. We are only talking about the colloquial references. Then you have a name. Name can also be trademark. Maybe we'll fall back on the MRF idea, MRF, right? Or maybe Kia, or something like Bata, right? A name can be trademark. It can be an abbreviation. Maybe something like right? Just an example. It can be Manish Malhotra, right? Or SM, Sabyasachi Mukherjee, right? So it can be just a name, or it can be something like I won't call it as a description, but the pronunciation makes it different. For example, we talk about NYKA. I'm not talking about Nike, Nike. No, I'm talking about NYKA. What's NYKA? Can somebody tell me what is this NYKA?
Nika.
What's
Nika.
Nika? What's Nika?
I think
So cosmetic company.
Right. So a few market analyzers say that it is it is modeled, on the name was modeled to indicate the women preference, the women entrepreneurship that we're talking about. It is meant for men. So we're talking about, maybe in different languages you have the phonetic differences coming in. For example, you may find something like Naika, right? Basically we're talking about somebody who's female, who's powerful, or who's center of attraction, right? So it can be a name, right? Then it can be combination of colors. Maybe it can be a tricky example, but I'll still go with what we had started the discussion with, the Google idea that we have, red, yellow, blue, green. So every Google product, every time it tries to load, it gives you those colors, right? So it can be a combination of colors, or it can be combination of any different marks, right? You can even have a signature. Yes, Mr. Manoj, you raised your hand. Do you have a question?
So you don't worry about it. There'll be an interaction session.
Okay, ma'am.
So they can
Oh.
raise your queries there.
Okay, ma'am.
If you don't want to stop the flow of your thought, kindly go ahead.
Okay, ma'am. Thank you. So you can have a signature, right? Or you can even trademark the shape of goods. For example, when we see a bottle, the image of a bottle, we recognize immediately that it is a Coke bottle, right? So we are talking about that shape of a thing can be trademarked, right? Or you can have something like the modern versions. We got something called as sound marks. For example, every time we try to watch a movie with 20th century fox, can you visualize the sound? You got the trumpet, drums, and all that playing. So you have sound marks. Or remember any episodes of Tom and Jerry, you got Metro Golden, MGM, you got the lion roar that is coming up. So these are considered as sound marks. You got the NBC Entertainment, or the 20th Century Fox, or the MGM Entertainment with the rolling lion. So you got all that. Then there are attempts at some point of time to have taste marks. So for understanding the new kinds of marks, I would suggest, what can be these new marks. So we have appearance, shape, sound, taste, touch, motion, slogans, and all this. There is an interesting paper brought out by WIPO. What is WIPO? Can somebody abbreviate WIPO for me? Or WIPO? Yes, ma'am.
World
World
Intellectual
World
Property.
Intellectual Property Organization.
Thank you. So they had come up with a sort of an, I won't even call it as a concept paper. It is more sort of a standing committee document. So the name of the document is New Types of Marks, came out way back in 2006, right? The name of the document is New Types of Marks. They're talking about appearance, shape, sound, taste. Now you can have a question as to how can something be indicated on a packaging with sound. So they're talking about the description of the sound, the notes that can come in, or how can somebody have something like a fragrance be considered as part of trademark. So there are a lot of questions that were there. So far we try to understand what is a trademark, what are the different kinds of it, and can it be for anything. One thing is sure, that it is for goods and services. Now, can it be for anything else? As far as I understand, no. Right? Now, there is also one other important idea that you have to keep in mind when you're reading about trademarks. There's a concept called as a well-known trademark. A trademark is something that is already defined. For example, we talk about section 2 ZB of the Trademarks Act. Maybe I'll just read the first 3 lines. Trademark means a mark capable of being represented graphically and which is capable of distinguishing the goods and service of one person from those of others, and may include shape of goods, the packaging, combination of colors, and it goes on. Now, what is this well-known trademark? Now, the simplest idea that I can tell you as of now is we understand that Tata is a brand which is there in India since a long time, or for that matter, Coke, right? So we are talking about some things which are there for a substantial time, or there is a substantial segment part of the public. We call it, for example, we say Xerox. The original word in English should have been photostat or photocopy, but we call it as Xerox. All shops use it as, we call it as a Xerox shop, but Xerox is the name of a company, right? So we are talking about some marks which get that stage, they are considered as well-known marks. So if somebody tries to make, let's say, uh, something like an laptop with a Tata mark, you'll be like, boss, can that be done? Is it from Tata? We understand that Tata got the electronics division, that is Chroma. The retail, Chroma offers are there every day. It's a Monday, you got some offer. It's a Friday, you got some other offer. So you got an electronics division. But we understand the Tata mark that we can see on the vehicles. So can we have a Tata Motors mark on a laptop? Right? So you have all such questions that come in because we are attributing this new product to that company or the conglomerate, right? So we're talking about the immediate thing. People know that this is Tata. So those are called as well-known trademarks. So in the law, over a period of time, with cases coming in, well-known trademarks have a little leverage over others, right? So far we spoke of what can be trademarks. Now, how do we get trademarks, right? So to start with, we can acquire trademarks by registering it, or what we call it as a first use, or you can adopt it, or you can use it for a long time. They call it as a long use, or which is the long use, which is honest, bona fide, and uninterrupted, right? It can be registered or unregistered to start with. Now, even if it is unregistered, it should be first use or an adoption, looking at how things had flown from one company to another. For example, let's say I run a spectacle making company. Now, I did not per se got my trademark registered. Now, let's call it as something like Two Eyes, right? So that's the name of the spectacle brand that I market. Now, I sell this to somebody else. Will they also get the trademark? So we're talking about it being an intellectual property. Now, at some point of time, the company which is making the Two Eye spectacles went on to make contact lenses also, right? Now, can they use the Two Eye if it is the same company? So that is clear. Now, when we diversify things, let's say one company makes spectacles, one company makes contact lenses. So somewhere down the line, if somebody wants to get something else, they may adopt using some other technique. So you got first use and adoption, right? But it has to be the long use, which is honest, bona fide, and uninterrupted. Are we okay? So we can acquire it by registration, or there can be unregistered trademark also. So can there be, what can be the characteristics of a good trademark? We realized what are the functions of it. So what are the characteristics of a good trademark? Any guesses? We spoke of the functions of it. We spoke of types of it. Any guesses of the characteristics?
They should be clear in identifying.
Can we go one after another? We'll go with Prakriti. Then Archana. Prakriti.
It should be unique. It should not be
Sorry, ma'am, I can't hear you.
be unique. It should not be identical with the others.
Okay, it should be unique. Okay, not identical with others. Okay, then Archana, you're saying something?
It should be easily recognizable. That the public should be like, if you see the logo, the public should be easily make out that, yeah, this is a product logo of the ABC product.
Okay. Now let's use the chat box, or you can unmute and tell me. When you think of chocolates, which is the brand that you're looking at? Which is the company that you immediately think of?
Cadbury.
Right?
Cadbury's.
Or when you're talking about shoes, which is the company?
Raymond.
What is there? Nike.
Right? So if you're talking about sports shoes, it will be one. If you're talking about some other shoes, it will be something else, right? So we try to see that these are marks that are created, trademarks that are created by these companies, but these are way too much. These are way too much into the public, life, that these are considered as some good trademarks. People can easily remember, or it is easy to pronounce, easy to spell. So that can be one. Or we'll go back to what Prakriti said. It should be distinctive, should not be similar to other trademarks. And the one which I've been talking about in the last 10 minutes, it should not be descriptive, because if it is a trade description, that is something which cannot be considered as a trademark. Now, what is this trade description? Now, if we dig deeper in relation to trade description, we are referring to the consent section, that is 2(1)(ZA). What is a trade description? It means a description, statement, or other indication, direct or indirect, as to the number, quantity, measure, gauge, weight of any goods or standard of quality, or any goods or services according to the classification commonly recognized. So if you say that, boss, I make sweet chocolates, right? That is a description. Now, can you have a trademark with sweet in it? No, please don't take it back to another question. Like we are referring to Nika, we also have sugar, right? What's this sugar? Can somebody tell us?
It's a cosmetic brand.
Cosmetic.
Right. So if it is sugar, is it descriptive of the goods? If you're talking about cosmetics, no. Is it descriptive of the goods?
No.
Definitely not. So it has to be seen. So that's where we have something called as classes. So we have Prajumna asking what are the benefits of registering trademarks. So before digging deeper, let's look at what is this idea of registration. Now we talk about products and the classifications. So under the law, you have various classifications. You can't register the trademark just like that. You have to determine which class are you looking at. So is it maybe goods, is it services, what kind of it, because you have something like textile marks, right? So all that are there. So in that notion, trade description has to be considered very carefully. So your trademark should never be descriptive if you want it to be a good trademark. And it should avoid, in the context of descriptor, it should avoid things like finest. We make the finest suits is a description. Or market knows that you make the finest suits or shoes, but you can't have it. The finest tailor. That can't be a trademark. It will be rejected in your application. But you also have an unregistered idea that is going on. So you want a good trademark, maybe have something which is easy to remember, spell, pronounce, or it is distinctive, should not be similar to others, and it should not be descriptive. Now, people say that there is something called as arbitrary mark. Now, what is this arbitrary mark? Like you got a descriptive mark, you got an arbitrary mark. Arbitrary mark is the name, or whatever we are talking about does not have anything to do with what is being sold or marketed. For example, if I say Apple, what do you remember?
Phone, watches.
Oh, not the fruit, not Newton.
Yeah, even the fruit.
Right? So this is the arbitrariness we're talking. What does Apple have with computers? Or what does Sun have computers? We talk about Sun, the Java applications that have, it is from the Sun systems, right? Or you have something like combinations, invented words. We talk about Bangalore. So it is the center of the software activity as of today. So can you name one or two software companies?
Infosys.
Right? What is this Infosys? Does it make is it Apple? We understand, but what is this Infosys? Basically, we had took different parts. The first four letters of information, first three letters of system. So you got Infosys, right? So you got fanciful terms, made up terms, invented terms, just like that. Exxon, Infosys, right? So people say when we're talking about a good trademark, we talk about what is the strength of the trademark, like the password strength. They talk about, how do you look at it, the strength of a trademark. They say that an arbitrary trademark is generally the strongest one. Apple in the class of computers is generally not thought of, right? Or it is fanciful also. So you got arbitrary, then you have something called as a suggestive version, not the descriptive version. We are talking about a suggestive trademark. So a suggestive trademark is something, maybe if you can use some bit of your imagination, you understand what is the nature of the product, right? For example, somebody says maybe something like smooth, right? If you're using it using it on a shampoo bottle, we understand it has some reference to what is the outcome. We're talking about the shampoo which can make the hair smooth. Or if somebody says something like boost, what do we remember if somebody says boost? Maybe our mothers for sure, all through the childhood, they'll be like, they'll ask us to drink some kind of an, energy boosting drink, milk or something added to the milk. So we are talking about boost. Are we okay?
Yes.
So
Yes, sir.
then you have the last one, the generic ones, which are generally not protected and they are weakest, right? Are we okay so far? So these are the ideas that we have to keep in mind while we are looking at the characteristics of good trademark. So we understand what is a trademark, what is the law that is applicable, how do we distinguish various trademarks, how can one acquire a trademark, registered, unregistered, what makes something a good trademark. So can I dig deeper into the registration part?
Yes,
Yes, sir.
please.
So when you want to register it, all said and done, a registered trademark is protected better than an unregistered trademark. We are not saying that it is not protected under law. You would have studied in torts that there's something called as tort of passing off. Basically, I try to sell my goods. I wanna pass off my goods as your goods. Now, how do we do that? You always got some symbol or some brand on it. I print it, I try to have it on the goods that I sell and try to pass it off as yours. So something like maybe you buy something on the Brigade Road or something you buy on the footpath. There's a difference. Somebody trying to sell things which are bootlegged, which are duplicate, which are counterfeit, right? They are passing off your trademark. So that's in the typical unregistered trademark scenario. But if somebody is trying to do that with a registered trademark, you will have the infringement remedies coming into picture, right? So that's the first benefit of a registration. Now, how it has to be registered, you have the rules that I referred, the trademark rules. Now you for greater clarity, what I want you to do is, there is something called as IP India, the website IP India, and in that they got a manual, a trademark manual. So I just paste the link. So you would find as to how do you file the document with the trademark registry, what are the things that are to be there, right? How do you identify the class? So you have everything, including the notions as to what is required, what are the things that you have to keep in mind, what is the information that I have to provide, or where you have to sign, who can get it, is it an shape, is it a brand, is it a label, is it a device, right? So you have to look at the application carefully. Then once you submit an application, the registrar will examine it, right? Once examined, if it goes well, wonderful. If not, you have some problems coming into picture. Now, if you can look at the two ways, you had to file an application, there are two things that can come up. Application is accepted, or there can be rejection, or even before rejection, there can be an objection, right? So if you file an application, it is accepted, they publish in their journal, the trademark journal, wherein they invite people's attention to oppose if there are any persons who is already using something similar. So if there are no opposition that were raised in 4 months, they issue the registration certificate. So this is the easiest way that happens, right? You got an application, you invent a new word, right? For example, I am Biola, Bayole, Biola. Now, if I go with something called as Biolaw, somebody who is living and who has something to do with law, Biola. So something that is invented. Now, I go with it, that's okay. Or somebody, one of you is going ahead with Biola, and I say that, boss, this is phonetically similar with my name, and I do the business with my name. So I am raising an objection, right? So that can be done by people who are outside once it is published. Or even before that, we spoke of refusal by the register or the registry in the first instance, section 9. Or you have various other ideas. For example, you can't use national emblems certain names that are there. You got Protection of National Emblems Act, I think maybe section 28 of it tries to talk about. So, and various other factors are also there. You can't have some kinds of things in your trademark. So there, within the registry, there can be an objection to the application, right? So you can submit a reply to the examiner, right? Once you give a reply, they may consider your application. Then it again goes into the application accepted stage. Or once an objection has been raised by the registry and you don't reply, your application is abandoned, right? Or you had replied and they are not okay with your reply, they can ask you to appear, show cause. Are we okay? So this is how the registration happens. So strictly speaking, once the registrar gives an acceptance, you get a trademark. Now, you got an acceptance of application or refusal, that's clear. Now, can there be something like withdrawal of acceptance? They had given you a trademark, but can they withdraw it? Now, there you have, maybe to be very specific, section 18. They're talking about the powers of the registrar to withdraw the acceptance of the application, right? It is accepted in error. That can be, something which cannot be ruled out. The acceptance is just out of an error. Or, if you carefully see the circumstances, it should not be registered, but somehow it got registered, not error, but the circumstances are bad. For example, let's say in a country which is maybe the country which follows a religious legal system. So any mark that goes against the religion, right, that can, unsettle the sentiments of people, that can hurt sentiments of people, that may be something that can be withdrawn, right? Or it was subject to be registered with some conditions or limitations that were specified, but it was not done. So in all such circumstances, under section 18, they can under section 19, I'm very sorry, under section 19, they can withdraw the acceptance that is given, right? So what is the benefit is the question. Now we are talking about something called as infringement, right? So the first effect of registration is a trademark, whether or registered or unregistered, is protected under trademarks law. But if it is registered, it gives you an undoubtedly an edge to fight for it. You can consider yourself as the owner of it. There is somebody who got an unregistered trademark and you had registered it. Now remember, we just spoke of the process. There is an application, right? Then it is, if the application is accepted, it will be published in the journal, inviting opposition. So nobody opposed. Now you got a registered trademark. Somebody says that, boss, this registered trademark is actually violating the rights that I have. I've been using this name in my trade for years together, but it is unregistered. So if it is registered, you got an edge over the owner in suing, they can't sue you for infringement because it is registered. You followed the law, it is published over there. The registrar invited opposition, so you were given that, right? When it is examined, they look at all factors. So for greater clarity, look at the manual that I said. They examine everything that is possible, including, is it descriptive, or is it something like, maybe you can look at chapter 2, how examination happens. Examination of application as to the classification, or, relative grounds of refusal, absolute grounds of refusal, or examination of series marks in certain situations. So you all that coming into picture. So it goes through the process of law, wherein you get that edge over unregistered user. Are we okay? He may be there beforehand, but you are using it after registration, so you get an edge. So that is the biggest benefit. Are we okay? Did I answer the question?
Yes, sir.
That doesn't mean that unregistered trademarks don't have legal protection. They have the thought of passing off, for sure. You can file the suit for passing off your unregistered trademark. Okay, all said and done. Maybe you can have a question, something like maybe a short question or an essay question with a single statement. It reads something like, a trademark exists independently of its registration. Discuss. That can be the question. So they are hinting you to look at the registration in general, but the protection that is available for an unregistered trademark. So that should be the core of your answer. So the question can be something like a single statement, a trademark exists independently of its registration. So can there be an unregistered trademark? Yes, for sure. Is it protected under law? Yes. If somebody tries to violate the rights that flow through your unregistered trademark, yes, law protects certain remedies. Are we okay? So
Yes.
the rights that come up, we spoke of benefits. The rights that come up once it is registered, the right to use the mark in relation to goods or services, which is registered for the class registration that we're talking. You want it for goods? Yes. You want it for services? Yes. So you are talking about the registration. When you file an application, you file as to which class you want to. For example, we again go back to the software idea of Bangalore. TCS. What is TCS? TCS anyone?
Tata Consultancy
Tata
Services.
Consultation
Software
Service.
Tata
company,
consultancy services.
software services. Now, can TCS also come up with goods? We're not talking about goodies. All our friends who join these companies post, the welcome kit, and they may get a pen or a mug or a bag. I'm not talking about one company. Companies give. No, are these goods? Are they selling it? No, these are goodies, right? These are maybe welcome kits that they call it. They are not sold, but you want to use it in marketing one of your goods. It should be registered in the concerned class also. But when it is registered, what we say is the right that comes up, apart from the benefit of protection in case of infringement, edge over the unregistered user of the same mark, you get a right to use the mark on your in relation to the goods and services to obtain the relief of infringement. If it is an unregistered trademark, it is passing off only. But in registered scenario, you can file a suit for infringement, right? So we'll talk about remedies in 1-2 minutes. But the notion is you get that right to sue people for infringement, right? You got reliefs. The reliefs can range for asking what are the, how many goods are sold, asking it to be accounted for. Then you got something like maybe what should I say, when we say that relief, you will ask for share of profits, or account, you can ask for documents and all those ideas that can be done, which is not directly there in the unregistered scenario. So maybe to talk about the last idea in relation to infringement, I would refer to N.R. Dongre versus Whirlpool Corporation, the Delhi High Court. I'll just read 2 lines. N.R. Dongre versus Whirlpool Corporation. Any IPR textbook with trademarks refers to this. Now, What we're talking about here is registered, unregistered scenario, just 2 sentences. The registration of trademark, though it gives an exclusive right to use the mark, is subject to the provisions of the Act, and it is not exclusive, right? So you get a right to use, but it is not an absolute right. That is something that you have to keep in mind. Now, any ideas what can be considered as infringement? Infringement of trademark. What can be the infringement of trademark?
When someone else uses the trademark.
Right? So if you dig deeper, the Act provides for almost 8 ways in which a trademark can be infringed. Right? So you are the one who had registered it in a class. So when the registered trademark is used by a person who is not a registered proprietor or person permitted to use. Now that person permitted to use is something we get across in relation to assignment. So hold the fort for a minute. We'll talk about it. Basically, you permit somebody to use the mark, right? Maybe Bata had said, boss, you can use it on the socks that you manufacture. They got a deal. Now, that is some kind of a permission given. Now, you are not permitted to use it. That can be one infringement. Or, you have various ideas like something which is deceptively similar. The mark Bata is used. Or we understand fonts. We use documents very clearly, for all possible ideas. So we understand the term font. Now I use the same font, right? BATA. We understand the Bata font. Now I go with something like BALA, right? So same font. So you got a deceptive similarity. Or maybe when you are traveling, try buying something like a biscuit packet, right? Ask them for good day, right? They may give you something like good bay, right? GOOBAY. Or remember those memes on Bisleri? The Bisleri spell says, any idea on Bisleri spelling?
Bisleri, sir.
Right? Any variation of the spelling, we can guarantee that you'll find a bottle somewhere. Right? You got Bilsari, you have all such coming, everything with that green cap and a green cover. So we are way too much dependent on autocorrect today that we don't remember the spellings that easily. So you wanted a Bisleri bottle, they give you a Bilsari bottle. So all these kinds are seen as per se infringement, and you can file a suit for infringement, right? Are we okay? So the consent provision that we are referring to is something like section 29. So like I said, hold the fort for a moment to understand assignment, right? What is this assignment and what is transmission? Now, what is assignment and transmission? Assignment in transfer property or in intellectual property, we are basically saying it is the transfer property. Now, what is this? It is the claim or the right. Somebody gets an interest. Now, what we say here is we want to convey the notion that in the sense, yes, you can use it. Assignment means assignment in writing by an act of the parties concerned. Now you ask, maybe you met, I take the classroom privilege here. Let's say you met Ratan Tata. You ask him, by whatever reasons, can I use the name Tata? Now he would have said yes or no, presuming that yes. Can you use it and say that, boss, it is assigned and I got permission? No. You have various other things that will be kept in mind. To be very specific, you got the AstraZeneca case of 2006, or you got the Sun Pharmaceutical case, wherein the courts had categorically said, when the act says assignment, it is assignment in writing by the parties concerned there. Right? Are we okay? So can trademark pass, the claim or right in trademark pass to another without assignment? Yes, we call that as transmission. Transmission is transmission by operation of law. nobody wrote it to you. People did not sit and agree, but it had transmitted. Like I said, maybe Google acquiring something like Pixar, Pixar, the Pixel. Now you got all the facilities of cloud storage of photos. Now you got Google Photos, right? So they get the rights transmitted, right? The trademark is transmitted. Are we okay? Now, why are we talking about assignment and transmission? The last notion before we move on to the repeated question that I can see is domain names, right? What do we get if we are talking about assignment and transmission? Now, we had seen right from the origin of trademark, it has a lot to do with commerce. Now, when we are talking about commerce, now, how many of you remember the Maggie controversy? What is this Maggie controversy?
It has the lead in it.
Right? So whenever we talk about instant noodles, we say Maggie. Now, irrespective of whichever noodles that you're using, we call it, I want to eat Maggie, right? Instant noodles are synonymous to Maggie in many households. Now, they had to run a campaign that Maggie is back, right? So what we're saying is each trademark or each business got a goodwill associated with it. Now, this goodwill, for example, we say Tata stands for quality. Now, if you don't protect your trademark, you don't, let's say, proceed against people who violate your rights, they may undermine the products that they make, undermines your quality, your reputation. So goodwill is something that has to be kept in mind. Goodwill is person, not trademark, right? A trademark can, can be seen as a part of business goodwill that has been built up over a period of time. Right? Now comes the serious question that has been repeating at least twice or thrice. Are domain names something that can be protected under trademark law? Now, to understand things better, I would want you to look at what is called as WIPO. Now, what is WIPO? So, can we pause the domain name question for, let's say, 2 minutes and just have a very quick overview of what is WIPO or WIPO? I use both. I'm okay with both. So, what is WIPO? Now, this is an organization, international organization, because it's the World Intellectual Property Organization, which has come into place in 1970 by virtue of a convention signed by member nations in 1967. Right? It tries to bring, I won't say streamline the law or relating to IP. It tries to, in a sense, maybe, what should I say, ensure that IPR disputes are settled in the peaceful manner. So they try to have a balanced and an accessible IP system, right? Not just the ecosystem of IP disputes, but we're talking about how IP can be protected to reward creativity, innovation, and at the same time use IP for economic development of the country in question. For example, you'd a friend was telling us you had a session on patents yesterday, right? So a patent, maybe the first thing that I can think of patent, maybe something like a pharmaceutical patent. We had COVID, we were waiting for vaccine. So there's a lot of investment that goes into research and development of a medicine or a vaccine. Now, under the intellectual property, you got a provision called as compulsory licensing, wherein whatever you had invented, created, or discovered, depending upon which is the law we are talking, can be made accessible to people, right? So that's compulsory licensing, right? So WIPO also looks into balancing these ideas. Now, why did this come into picture? Now you can talk about the roots of WIPO being there in the first problem that had come up in relation to innovations. Right, we're not talking about light bulb ideas, but we're talking about the exhibition of innovations in Vienna, 1873. Right, so people, we are talking about the maybe high stages of industrial development that is slowly taking up, people were trying to invent things. So if you exhibit, maybe for example, how printing press had altered, or how wheel had altered the world. So an innovation can change things. Now people way back then were not ready to come and exhibit their innovations because they were scared to exhibit it in public, because somebody may copy it, so and they may commercially exploit it. So all the effort that they had put in will be used for the benefit of another. So from there you got the 1883 convention, right? You got the Paris Convention, Bern Convention, right? All that. So you got WIPO, maybe. So you got something called as International Bureau of Protection of Intellectual Property. That is the French word. So you have something called as BIPPI, BIRPI. The English translation is the International Bureau for Protection of Intellectual Property, right? So you also have, remember TRIPS, we made a reference. You got TRIPS under the WTO, because you have business has a lot to do with intellectual property. So you wanted to have some kind of, I won't say work division, but some kind of cooperation agreement between the institution that is looking at intellectual property and WIPO, with the WTO, which got the TRIPS agreement. So you got the UN system coming into picture. You got the 1996 WIPO expansion, wherein after WTO TRIPS agreement, you got the cooperation agreement with WTO. So there are 9 strategic goals of WIPO. Balanced evolution of international normative framework for IP. Basically, the balance between creativity, rewarding creativity, and public benefit. Maybe provide the premier global IP services, maybe something like the domain name resolution we talk about in maybe 2 more minutes, right? How do we facilitate the use of IP for development, coordination of different global IP infrastructure. So they have all that. On the organizational structure, you got maybe 3 important things that are to be kept in mind. You got a WIPO General Assembly, right? You got a WIPO conference, you got WIPO coordination committee. So now what does this do? Now WIPO General Assembly is like maybe all member states of WIPO, they are there. They would, out of many functions that they have, they appoint the Director General, they approve and review the reports of the Director General, right? Maybe they talk about the budget, they talk about financial regulations of the organization. Then you got the WIPO conference. Now, this is also comprised of WIPO members. Now, this meets once in every 2 years. We are looking at, a conference, a body which meets every 2 years to discuss matters of interest in the field of IP and adopt recommendations which are to be forwarded for changes that are to be brought in. Then you got the coordination committee, you got the General Assembly, you got a conference. So you want something called as a coordination between various, because you got the Bern Convention, Paris Convention. So this coordination committee meets every year in an ordinary session, and they try to coordinate between the Director General, General Assembly, conference of parties, and all that, right? Now, we said WIPO is looking into dispute settlement, so they got an arbitration and mediation center, and you have something called as the internet, which had altered trademark law like anything over a period of time. To start with, if you wanna, buy something as of now, let's say if I suggest you to look for a book, what is the first place that you search today? Internet, for sure. From there it'll take you to something like Amazon or Flipkart or some law agencies or law publishers website. So we if we fall back on internet, it is a network of computer systems that are placed in different parts of the world. They are connected. So each system, right, each computer, it can be a server or it can be a device. We are talking about an address that is given, that's called as maybe the IP address, right? When you try to look at maybe 4 sets of numerical separated by 3 dots in between, we are talking about the IP address. Now each computer got an IP address, each server will have an IP address, so you connect with that. Now it will be difficult to remember the numbers, so they got something called as ICANN, wherein somebody would remember or keep record of what are the numbers that are given, what are the alphabets that are given. So from there you get what is called as domain name. For example, if you look at the address bar on the laptop right now browser, you would find meet.google.com, right? These three things that are there. So this is considered as your, maybe let's call it as an address, right? So in that you have different parts of it. You got domain name, right? The generic tertiary level, second level. So .com, the notion is it is commercial. .edu, educational, right? Or .biz, business. Now, when we look at something like .gov, it is government. But when it comes to India, you have something called as gov.in, Indian government. Now, gov, let's say you type something like maybe commerce.gov or Ministry of Commerce.gov, the notion is it will open the American Ministry of Commerce. But you want an Indian version, maybe you have to talk about gov.in. So we are talking about country level domain name. So you got IN for India, or DE for Germany, or FR for France. So you got, these are country level, the last one. So then you got the generic level, that is .com, .edu, or .ac. So these are, now before that is something that we are concerned about. For example, .com is common for any commercial entity as per how it comes from ICANN. Now Google, right? Now we are okay when we spoke of classes, right? I had a reason for having TCS as an example. We spoke of TCS trademark for software services. Now TCS wants to have goods. We realize that that's a very let's say long fetched example, or my imagination is stretched way too long. So somebody can have TCS, if it is not a well-known trademark, for some goods, right? Now you can have two in the physical world, one for services or one for goods, or one for one class and one for some other class, right? You have something like maybe a textile, for example, something like a glanza, right? Glanza is a fabric that is marketed by Ramones, but you got a car which is glanza, right? So in the physical world that is possible because it operates on a very different platform. But when we're talking about domain name, you can only have one Google, right? Because we talk about the binary system, all alphabets that the networks use is in the binary system, zeros and one. So you can only have one Google, right? So can a trademark be used in a domain name? Was something that started with the internet coming into picture and websites, people, commercial presence that had started. Now if somebody can have it, okay, good. Can anybody have it? So you got domain name disputes ranging into two different ideas. Number one, what is called as cyber squatting, or you also have something called as typo squatting. So you have something called as Amazon. The spelling of Amazon is AMAZON. Now how many of us check the web address when we click on a link? Now if you look at what is called as the boat, heard of boat? Boat, earphones, earpods, Bluetooth speakers, soundbar. Heard of it?
Yes, sir.
It is one
Yes,
of the
sir.
Indian companies that made impact with the Make in India scenario. Now they got a Republic Day sale, right? They were offering, I think, 50 to 70%. So if you had used any of the social media, you'd find that this was used by somebody else. What happened is somebody made a website which reads as www.boataudio.in. Now the web page is similar, products are similar, and money was swindled, counterfeit goods were sold. Now, Boat had come up with an press statement very recently, I think 2 days ago, saying that Boat Audio .in has nothing to do with us. Our official website is boat-lifestyle.in. Now, you got loss of revenue happening there, loss of reputation happening there, unnecessary hassles coming in. So, can I, who has nothing to do with Boat, register a domain name with Boat in it, somebody's trademark? So that's how you got questions. Now, you have Boat in the physical world, the Boat audios. You also have Bolt, B-O-U-L-T, right? So we are talking about different trademarks with phonetic variations, spelling variations. So can we do that in internet also? No, I don't want to touch Google. I go with a Google with 3 O's, right? Or I go with a Google with double E at the end. Or I go with a Google with a double G. So what I'm trying to do is I am trying to ride on the tail of somebody's development. People, in websites we see number of visitors. Depending upon the number of visitors, you have an ad revenue coming in. So over a period of time, what people did, these cyber squatters, typo squatters, registered the names. Once you get a domain name with Tata, you are the first one to wake up. You realize that yes, internet got scope. So you got Tata, maybe Reliance, every other important business house in India, you got those names registered as your domain names. Now, you open www.tata.in at that point of time, and somebody is selling Tata's competitors' products there. You got a problem, right? It is not just, your trademark violation. Somebody is taking away business also. So there, people try to use the civil court route, or even in certain cases the writ court route, to get hold of the domain name, right? Tata filing a case against somebody, or Yahoo filing a case against somebody who had registered the domain name. So you got a WIPO level domain name dispute resolution. What happens today is you file a complaint, they'll consider either they take down the domain or they will get it assigned to you, right? So that's WIPO and domain name relationship put together simply, right? So I told you very clearly that it will be difficult to cover all aspects, but I just take one last aspect before we close. Ma'am, I understand I am almost near the end of the time, but I just wanted to draw attention of people to the offenses that are there under the Trademark Act. So like I asked you to download the Bear Act, if you can find sections, let's say maybe starting from 103 to 109, you got various offenses and penalties that are listed. So you have, once you understand the offenses, then you understand why, what are the benefits of registration, what are the benefits of, having a trademark. Section 103 basically talks about falsifying the trademark, or applying a false trademark, or having a false trade description, tampering with the indication of origin, altering the address of the manufacturer, etc. You have maybe infringement up to starting from 6 months to 3 years, fine of 50,000 to 2 years, 50,000 to 2 lakhs. I think this is subject to the latest changes. I did not check. I don't have the latest copy of the Bear Act. I'm very sorry for that, right? Or 104, selling goods or services with false trademark. You have a very the punishment is same, 50,000 to 2 lakhs, or an imprisonment of 6 months to 3 years. Or second conviction under 103 or 104, the imprisonment can range from 1 year to 3 years, and fine range from 1 lakh to 2 lakhs, right? Or you got something like under 107, falsely representing a trademark as a registered trademark. Now we spoke of unregistered trademark being protected. Now you represent an unregistered trademark as a registered trademark. You got an imprisonment up to 3 years, or fine, or both. So you have all such ideas that are there. Now, what are we talking about here? The simplest question that I want to refer here is, what is the benefit of registering your trademark? You have some relief that can be claimed, like I said, discovery of documents, preserving of infringing goods, documents, it is in their possession, but you can get it covered. You can restrain the defendant, right? You have the John Doe orders and all that coming into picture, right? So I stop here for questions. I presume I covered all the bases that are given, and I'm very sorry I cannot cover it at a deeper level.
Thank you very much, sir. We enjoyed it thoroughly. It's a very knowledgeable session. But could you please tell us about the trade redress, sir?
Trade dress, ma'am. Okay, sure. Anything else? Or will we go question after question?
So I think you have been very, very clear and lucid and explained things at length. So you can answer the specific question, and if anyone is willing, they can come directly and ask you questions.
Okay, ma'am.
Otherwise, you've been fairly clear, sir.
Okay, ma'am. Now, the trade dress, I won't go deep into the nitty-gritties of it. Now, how do you, maybe we spoke of packaging coming into picture. Now, let's say the simplest example that I can talk about is when we talk about the biscuit packets, right? Good Day got some color codes that are there. If it is butter cookies, maybe something like blue, or cashew, you got a different version like maybe orange tint of a red, or you got maybe dry fruit version, some pista green color coming into picture. Now, when you have the Good Day cookies with blue in color, right, and I try to get another biscuit packet of my company, not Britannia, which has a similar packaging. So we are referring to the trade dress, and can trade dress be protected under law? Am I trying to infringe somebody's rights? Now, the easiest example that I can suggest here is, next time when you go to an supermarket, the local chains or an international chain, you have the goods that are sold by companies, and the supermarket got its own brands. So you got something like an maybe if you talk about Maggie, the Maggie packaging color is dominantly yellow. Now the supermarket, I'm not naming the supermarket, every supermarket chain got its own noodle brand. Now if it is also yellow, with that red edges or the font, so there is an idea that when you are, for example, in a city like Bangalore, time matters. Traffic determines your speed. So you go to a supermarket, you pick up what you want and you run. So, and the economics of supermarkets say that all similar goods are kept at one place. So all instant noodles are are in one aisle and at one level. So you pick an yellow packet, you think that it is Maggie, and you come home and you check that it is not Maggie. So we're talking about violations of your trade dress related rights. Are we okay, ma'am?
Yes, thank you very much, sir.
Next question. Service mark. Oh, interesting question. Maybe I will try to refer to the certification mark, because there's a confusion that comes up everywhere. We spoke of the hallmark, the BIS hallmark. The Bureau of Indian Standard gives the hallmark, or UG mark, or wool mark. We have all that. Now when you have the goods, you got the marks that are made. I think they try to bring a definition to service mark. Just give me a second, I'll tell you how they wanna put it now. Shape of goods, sound marks. As of now, I can't find the service mark definition as it is understood by the market. But what I'm trying to refer is section 21G, 21Z, and the consequences of the definition of service associated with the mark, right? So the 21Z says, Service of any description which is made available to potential users and includes provision of services in connection with the business of any industrial or commercial matters such as banking and all these commercial activities that are there. Now over there also, we said a trademark can be in relation to goods and services. So service mark is, the thumb rule is we go on that side. Now for example, SBI is YONO. Now I offer something called as XONO, and I offer banking services. Now, is this violation of SBI's rights? Yes, definitely, because they got a mark which is, akin to trademark, but it is into services, right? Maybe Chetan was saying FedEx is an example of service because it is put into service. It is not into trade like, goods. Did I answer all questions? Let me check the chat box one more time.
Sir, I have a question.
Yes, Archana.
Sir, there are many indigenous, uh, products or indigenous food
Archana,
that goes
I'm not
in.
getting your voice clearly. Can you type it in the chat box?
Archana, little louder.
One second.
Yeah, then in the meanwhile, I'll answer Chetan's question whether word gives description can be registered in a trademark act. Now, if it is a descriptive, like I said, few jurisdictions accept some kind of a descriptive marks to some extent, but in the Indian context, it is generally no. Now, how do we identify deceptive similarity in a trademark? There are tests that are laid down in various cases. You got maybe the Whirlpool case and the Singer case. You got the Eagle case. So there are various tests that are laid down. So you got various doctrines that are there. So you have those things that are to be put into operation. Now, there's another interesting question. Navya is asking, if two people are using same mark and neither is registered, who has more rights? Now, as long as these two people don't fight, everybody's okay. The question is, let's say I have maybe something like, I have a name called Beagle for my business. Now, what I do, I sell maybe pens, right? Now you have a very similar name. Let's say Beagle only. You sell something like cycles. Now, as long as the markets and the classes don't coincide, we don't have a problem. Now, I make Beagle pens. I'm there. Let's say located somewhere in Visakhapatnam, right? I cater to market here, right? And you also make pens. You cater to market there. Now, it was going wonderfully over a period of time before e-commerce had stepped in. Now, I try to sell my pens on internet. You try to sell your pens on internet. Now, that's when disputes start, right? As long as people sit and discuss, deliberate, okay. But when we are talking about who got better rights, maybe we are talking about not just the class, we are talking about the longest use. Like I said, there are various doctrines that come into picture. Now, how can I find out if somebody is using a trademark if I am interested in registering? Like I said, the trademark journal they publish, you can check it there. Assignment of a trademark, are there any restrictions? Yes. Maybe we have to refer the legislation when they talk about, can it be assigned irrespective of the class or can be assigned within the class only? So they have all that. Now, Jagadish has a question. My client runs a computer hardware retail shop and registered a logo, has a registered logo and name, Computer Point. So, is it registered with the shops and establishment, authority and the shops and establishment, or is it a registered trademark? Now, this takes us to one other interesting question. Now, when you look at any, trademark, or for example, maybe once you look at the toothpaste tube tomorrow, you'll find the logo, and on the top of it you either find TM in circle or R in circle. Now both got its own repercussions. One has to do with registration, one has to do with boss it being a trademark. So is it registered logo with maybe as a trademark or not? That is something that has to be kept in mind. So we presume that, let's say, it is a registered trademark. Now whether that can be registered because it is in a sense descriptive, computer point, you may find all things that are necessary for computer, right? A computer point, and has been running it for many years. Someone opened a new shop in the same trade by new computer point right in his neighborhood. My query is, can the computer open a shop by adding new to the existing name of my client shop, right? I won't dodge the question, but I will only take one example. If somebody has to eat, some authentic tiffin in Bangalore, maybe people say that maybe something like MTR. I think MTR is in Bangalore. If not, don't accuse me. So right opposite MTR, I open new MTR. Will that be violation?
Yes, sir.
We have violation happening in unregistered scenario. The same thing can be done with registered also. Like we said, we have 8 versions of infringement. So you have all this. You make a very small change, which has no deeper impact to the name, right? For example, if somebody goes with something like, instead of computer point, I say compu point, will it still be violation? Yes, there is a possibility, right? Or if somebody uses the computer point as a part of some other, not new computer point, let's say something like 3 names of gods or goddesses, or 2 movie superstar names are added, and you have a big name. So then you got a problem, because we are talking about computer point being descriptive. So if it is registered trademark, you have a better right. But I think computer point may not be given the trademark register just like that because of the description, right? Are we okay, Jagdish? Any other questions? And I'll be happy if somebody can point out mistakes or anything that I missed in the time period. And if at all I had caused any confusion, I'm very sorry.
No, sir. It has been very, very clear. You've taken a lot of pain. We are very appreciative of it. It has been a wonderful session.
Thank you,
So
sir.
if there are no other
Thank
questions, we'll call it a day. Ma'am, it's all yours, ma'am.
Yeah, thank you, sir. To conclude with, we have the vote of thanks proposed by Nandini, 5th semester BCom LLB. Nandini?
Yes, ma'am. We are immensely grateful to Mr. Posarla Boyala Kiran, Assistant Professor, for delivering an erudite lecture on trademark law. I also specially thank Mr. Chetan Kumar TM, Assistant Professor, RL Law College, Belagavi, Mr. Dundappa B. Solapure, Principal, KLE Law College, Chikkodi, Dr. Vidya Shettam Navar, Assistant Professor, KPEC Law College, Dharwad, Dr. Jagdish Hallashetty, Advocate, Bengaluru, Mr. K.T. Bhatt, Advocate, Bengaluru, and alumnus VCL, Madam Pratibha Honnapura, Additional Government Advocate, High Court of Karnataka, Mr. Bharat Y.J., Advocate and alumnus VCL, Madam Purnima D., Advocate, Supreme Court. Mr. Posarla Boyala Kiran sir, it has been a pleasure to listen to you and understand the nuances of trademark law. On behalf of Vivekananda College of Law and all the participants, I express profound gratitude to you, sir. Thank you.
It was a
Thank you, ma'am.
wonderful
It's my
session.
pleasure.
Thank you so much, sir.
Thank you so much, sir. It was a wonderful
It's a
session.
wonderful
Thank you.
session.
Thank
Thank you so much.
Thank you, sir. Thank you very much.
It's my pleasure. It's my pleasure.
Thank you,
Ma'am,
sir. Thank
I'll
you.
leave the meeting, ma'am.
Yeah, sure, sir. Thank you.
Thank you.
Thank you.
Thank you, sir. Ratish?
Ratish, ಇದು ರೆಕಾರ್ಡಿಂಗ್ ಸೇವ್ ಆಗಿದ್ಯಾ ನೋಡಿ. ಪ್ರದ್ಯುಮ್ನ?
That will be